Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 141, and we have of course three cases to discuss. The first one is a case that decided earlier this week, ABC and Others and Telegraph Media Group Limited. It is a really interesting case on a very topical subject, namely non-disclosure clauses in settlement agreements. And the issue is whether the employer and the subject of the allegations, a senior businessman, could obtain an injunction to prevent the Telegraph publishing details obtained apparently in breach of the NDAs. Secondly, we've got a case on the importance of context in assessing whether or not there's been unlawful direct discrimination or unlawful harassment. Thirdly, we've got a short case just dealing with an immigration matter. In particular, if an individual is dismissed because he or she does not have the necessary immigration documentation, the right to work, I should say, is it necessary to allow them a right of appeal? Please don't forget you can access the podcast via iTunes, Mayor Brown website or YouTube, and the Twitter feed, which is Nicholas Robertson at Nicholas ROBER11. And that's, of course, where we put out the links to all the cases. So, ABC and Others and Telegraph Media Group Limited. This is, as I say, it's a really important case on the use of NDA clauses in settlement agreements, and it's difficult to think of a more topical subject at the moment. The claimants in this case, two companies and a group of companies and a senior executive of that group. You will probably have read about this because it's all been all over the press recently, with lots and lots of speculation about the identity of the senior executive and then allegedly his name being disclosed in Parliament. And I know there's been a lot of stuff about his identity, but that's not relevant for the purposes of this report. We're just going to look at the Court of Appeal decision, which everything was anonymised. So, according to the outlined facts in the Court of Appeal, 5 employees of that group of companies had made allegations of inappropriate behaviour by the senior executive. 3 went through the internal grievance process, 2 just made allegations. Of the 3 who went through the grievance process, 2 of them then issued separate proceedings in the Employment Tribunal. All of the claims were compromised by settlement agreements. Payments, which were described as, quote, substantial, unquote, by the Court of Appeal, were made to the complainants. They all signed settlement agreements. They all had independent legal advice. In all of the agreements, there were terms under which both sides agreed to keep the subject matter of the complaints themselves and various associated matters confidential. It included the amount of money paid. There was, the Court of Appeal say, the right for the complainants to make legitimate disclosures, including reporting any criminal offences if they so wished. The 2 Employment Tribunal claims were settled early on and before details of the cases went on to the full public record. What then happened was that in July this year, the Daily Telegraph got in touch with the claimants. Remember that the claimants in this context are the companies and the businessmen. Got in touch with the claimants to get their comments on the story that it was proposing to publish about the complainants' allegations and how they'd been handled, up to and including the existence of a settlement agreement and the NDAs. The claimants asserted that the information had been obtained by the newspaper in breach of the NDAs, and so they immediately commenced the proceedings. Interestingly, early on in the proceedings, the judge dealing with matters at that stage directed that the parties should establish, with the original 5 employees who'd made the complaints, what their attitude was to granting an injunction to enforce the NDA and prevent the Daily Telegraph publishing the story. 2 of the 5 employees said they supported the application for the injunction to prohibit publication. One said they were opposed to the application, and one said that they would be happy for publication to go ahead provided their name was kept out of things. Procedurally then, this kicked off in July, and in August the High Court declined the injunction, for reasons which we'll come to. The Court of Appeal then heard an application for the injunction, an appeal for the injunction on 25th September, and by virtue of the judgment handed down on 23rd October, the injunction was granted. Sorry, spoiler alert, but there we are. The injunction was granted. So, let's look at that in a bit more detail. The legal background here wasn't really in dispute. The claim was for an interim injunction to restrain the publication of information obtained by the Daily Telegraph, it was alleged, in breach of confidence. This meant that Section 12 of the Human Rights Act and Article 10 of the European Convention on Human Rights were directly engaged, and it was also necessary to bear in mind Article 8 rights of individuals who might be featured in the publication. By way of background, Article 10 is the article dealing with freedom of expression. Article 10.2 provides some limitations on that fundamental right, and says that, quote, the right of freedom of expression may be subject to formalities, conditions, restrictions or penalties as are prescribed by law and are necessary in a democratic society for the protection or for the reputation or rights of others or for preventing the disclosure of information received in confidence. Unquote. Article 8.1 is the right to respect for private and family life, and obviously it can be seen that if you're alleging that a senior businessman has behaved in a sexually appropriate way, that is going to have an impact on private and family life, both the alleged victimiser and the alleged victim. Section 12 of the Human Rights Act says that if there is to be an injunction potentially affecting the right to freedom of expression, that relief can only be granted for trial, up to trial, if the court is satisfied that the claimant is likely, quote unquote, to establish that the publication should not be allowed at the end of the day. The court has to take into account in particular the right to freedom of expression, and if the material is journalistic material, it's relevant whether that information is already available to the public or it would be in the public interest for the material to be published. The High Court, when the application for the injunction came to them, decided that the allegations were reasonably credible, that there was little or no reasonable expectation of confidentiality or privacy in respect of the information, that a considerable amount of the information was already in the public domain, that it was not demonstrated that the information had been obtained in breach of the NDAs, and that, in the judge's opinion, publication of the information would be in the public interest. But he granted a temporary injunction pending an appeal to the Court of Appeal. So what did the Court of Appeal decide? Well, the Court of Appeal reviewed the leading authorities in this area, and in particular two cases. The first is the Prince of Wales and Associated Newspapers case back in 2006, where confidential material was leaked to the press, and the Court of Appeal had to decide whether or not to grant an injunction. In that case, the court decided that the test to decide whether or not it's necessary to restrict freedom of expression in order to prevent disclosure of information received in confidence, that test was whether it was in the public interest that the duty of confidence should be breached. It's necessary, they said, to look at the nature of the information, all the surrounding circumstances, and whether in those circumstances it is legitimate for the owner of the information to keep it confidential, or whether it is in the public interest that the information should be made public. Obviously, it's a balancing exercise, and as the Court of Appeal in the Prince of Wales case put it, the test is ultimately a proportionality test. The court accepted in this case that there was an express contractual obligation of confidence applicable to the person who had breached a duty, and on that basis, the fact that there is an express contractual obligation arguably means that this express duty carries more weight. But the Court of Appeal are also very clear. Provided the agreement is freely entered into, the one that contains the NDA, it's without improper pressure or other vitiating factor, and with the benefit, where appropriate, of independent legal advice, and again, where appropriate, with due allowance for disclosure of any wrongdoing to the police or appropriate regulatory or statutory body, the public policy reasons in favour of upholding the obligation, quote, are likely to tell with particular force and may well outweigh the Article 10 rights of the party who wishes to publish the confidential information, unquote. Court of Appeal also referred to the Mayonnaise and Democratic Press case, which was to do with libel proceedings, so it wasn't an employment dispute. However, in that case, the Court of Appeal said that where the relevant contract containing the confidentiality clause was in settlement of litigation with the benefit of expert legal advice on both sides, quote, it seems to me that it would require a strong case for the court to conclude that such a bargain was disproportionate and to refuse to enforce it other than on ordinary contractual or equitable principles, unquote. The Court of Appeal also pointed out in the Mayonnaise case that there was an important rule of public policy that parties are generally free to determine for themselves what primary obligations they accept, and that legal certainty required that, if they agreed something, then, other things being equal, that agreement would be enforced. The, quote, the principal reasons for upholding a bargain freely entered into obviously apply to one that finally disposes of litigation with particular force, unquote. In short, if you agree an NDA in disposal of a litigation, there's even more of an incentive for the court to look at holding you to the bargain you freely entered into. Now, here, just by way of reminder, of course, it's not the individuals who are looking to get out of the NDA, it's the press that are looking to come on board and publish stories, in some cases against the wishes of the employees. Well, the Court of Appeal worked through the 5 reasons given by the High Court judge for granting the injunction. The judge had decided, first of all, that the information disclosed was reasonably credible, but the Court of Appeal said that that view overlooked the fact that some of the allegations had been addressed in detail and rejected in detail by the claimant companies in their internal investigation. The most serious allegations made by the complainants have been denied, and the NDAs, moreover, made it difficult for the claimants to rebut the allegations, given the claimants themselves were bound by the NDAs. The High Court judge had originally found that there could be little or no reasonable expectation of confidentiality or privacy arising out of the behaviour. But the Court of Appeal said that the individual employees having entered into NDAs, the real issue was whether breach of confidentiality was justified by the public interest. The judge had also thought there was a considerable amount of information in the public domain, but the Court of Appeal disagreed, and the Court of Appeal also thought, contrary to the judge's opinion, that it was reasonably likely that the information had been obtained in breach of the NDAs by the Daily Telegraph. That left the 5th and final and crucial factor: the High Court judge's decision that publication of the information would be in the public interest. The Court of Appeal came down pretty heavily on the judge on this point. They pointed out the judge had left out from his judgment entirely, quote, the important and legitimate role played by non-disclosure agreements in the consensual settlement of disputes, both generally, but in particular in the employment field, unquote. The Court of Appeal quote, at some length, the Women and Equalities Committee report, which was done earlier this year, and that report expressly recognises that NDAs have a place in settling complaints of sexual harassment in the workplace. The committee's concern was that there is insufficient oversight and regulation of NDAs, and it would be inappropriate to prevent victims reporting matters to the police, regulators or other appropriate bodies or individuals. The report also expressly recognised the benefits to individuals of NDAs and settlement agreements. Employment lawyers, they said, agreed that NDAs were important to enable victims of sexual harassment to get a settlement from their employer. Court of Appeal cite the report, saying, quote, we acknowledge there is a place for NDAs and settlement agreements. There may be times when a victim makes the judgment that signing an NDA is genuinely in their own best interests, perhaps because it provides a route to resolution that they feel would entail less trauma than going to court, or because they value the guarantee of privacy, unquote. Equally, the Court of Appeal pointed out that the employees themselves may wish to maintain confidentiality in relation to the settlement of the dispute with the employer. And don't forget, that was the case for 2 of them here. The Court also states, referring back to the Women and Equalities report, non-disclosure agreements made as part of a settlement of a dispute will often be for the benefit of all parties to it. In the case of settlement of an employment dispute, the employee may have as much concern to maintain confidentiality as the employer. The employee may not wish details of the dispute or the terms on which it was settled to be disclosed more widely for a variety of reasons, such as to maintain personal privacy or in case it might affect future employment opportunities or for financial reasons, unquote. So on that basis, Court of Appeal here grants the injunction and makes an order for speedy trial. Immediate publication by the Telegraph would cause substantial, immediate and potentially irreversible harm towards the claimants. And for the claimant companies, of course, that would also have implications for their employees. So, step back, what's the significance? I think this is hugely significant and, dare I say it, a very sensible decision. The Court of Appeal is in essence saying that unless there is evidence of bullying or other similar conduct that would undermine the concept of the employee consenting to the settlement agreement, then the employee has freely entered into that settlement agreement, and the normal rule would be they would be held to the bargain that they have created. Secondly, the Court of Appeal is saying NDAs are not by themselves objectionable, and I think this point has sometimes been lost in some of the commentary coming after the Weinstein settlement document, which, if you remember, resulted in various comments being made at the report, in the Women Equalities report. We've certainly had claimant lawyers assert to us that their client could not be expected to sign an NDA as a matter of law or principle, and I think that view is now clearly incorrect. And again, we've spoken with lawyers who act solely for claimants, and their view has been that claimants often genuinely want the non-disclosure clauses too, put it behind them. They want to know that the matter is not going to come up again from the employer's side any more than the employer would want it to come up again from the employee's side. Clearly, it's crucial that the non-disclosure clauses are framed in the appropriate way. There seems to be a general acceptance, which we have seen reflected in recent practice, that non-disclosure clauses have to have exceptions for whistleblowing disclosures, criminal offence reporting, and for disclosures to any appropriate regulatory authority. And I think if you're signing up NDAs these days which don't have those express exceptions, that's quite risky. I think the case leaves very little doubt that on the state of the law at present, the courts are comfortable with appropriately drafted NDAs, as indeed were the Women and Equalities Committee. On that basis, as I say, I think the Court of Appeal's decision here is a very sensible and reasonable one. So that's the case for ABC and Others and Telegraph Media Group Limited, and whether the Court of Appeal would grant a temporary injunction to enforce an NDA. So, second case, Bacali and Greater Manchester Buses (South) Limited. This is a case that identifies very neatly the importance of looking at the context when deciding whether an individual has been directly discriminated against or has suffered unlawful discriminatory harassment. The background facts were that the claimant worked from 2008 until 2015 for the respondent. He was a bus driver before he was dismissed, and he identifies himself as being of Moroccan origin, and he is a Muslim. In October 2015, the claimant and one of his colleagues, Mr. Cotter, were having a conversation about an article on Islamic State fighters. According to the claims submitted by the individual, the claimant quoted some of the article's comments and findings made in the report, including the opinion of the journalist writing the report, that IS were trying to enforce law and order and its subjects, and that they were confident and proficient fighters. At a later date, but still in October 2015, the claimant and Mr. Cotter were again talking, and Mr. Cotter said to the claimant, quote, "Are you still promoting IS/Daesh?" unquote. The claimant alleged he was upset by the suggestion that he was promoting or supporting IS. The claimant and Mr. Cotter then went into the canteen together, and there was an incident between the claimant and another employee, Shane Tompkinson, which occurred in front of a female canteen worker. Her account was that the claimant had asked her for a cup of tea and then turned to Mr. Tompkinson and said sorry, to which Mr. Tompkinson replied, "No worries, go ahead," and then the claimant started shouting loudly, saying, "Why are you saying that to me? Why should I be worried?" And the female canteen worker said she found the claimant frightening, aggressive, very intimidating. Mr. Cotter apologised to the claimant for having upset him previously, but the claimant was subsequently dismissed for threatening and abusive behaviour, which was found to amount to gross misconduct. At the Employment Tribunal, the central allegation was that Mr. Cotter approached the claimant in the canteen and unexpectedly said, "Are you still promoting IS/Daesh?" This was claimed to be direct discrimination and unlawful harassment. Well, the Employment Tribunal accepted that Mr. Cotter made the comment. They said that had the comment been made in isolation, they might have concluded the claimant had proved facts from which the Employment Tribunal could have concluded it was an act of religious discrimination, given the claimant's a Muslim. If the comment had been made without this context, it would seem to link the claimant's religion to the possibility of him supporting ISIS. However, the context the Employment Tribunal said, in which Mr. Cotter made the remark, was it followed the conversation about positive-sounding comments from the German journalist about ISIS. Mr. Cotter understood that by making those comments, the claimant was promoting ISIS. Therefore, the claimant proved neither discrimination on the grounds of his Moroccan national origin nor his Muslim religion. Turning to the harassment claim, the tribunal accepted it was unwanted conduct for Mr. Cotter to make the comment, and that it could have had the effect of creating a degrading, humiliating or offensive environment, but it wasn't related to religious belief or racial belief for the same reasons that it rejected the discrimination claim, and therefore the claim failed too. The claimant appealed to the EAT, pointing out that the test for direct unlawful discrimination is a different test for unlawful harassment. If you're going to show direct discrimination, the tribunal has to be satisfied that the discriminator treated the victim adversely because of a protected characteristic. However, for unlawful harassment, it's harassment if the harasser engages in unwanted conduct related to a relevant protected characteristic, which has the necessary effect. So one is because of and one is related to. In short, the test for unlawful discrimination is wider and easier to meet than the test for direct discrimination. The appeal to the EAT was on the basis the tribunal had not gone back and looked at the different tests. In essence, it was said, the tribunal, having rejected the direct discrimination claim, had gone astray in therefore also rejecting the harassment claim. The claimant relied, for example, on the absence of any evidence as to why Mr. Cotter had made the remark about ISIS on 19th October. Why was Mr. Cotter not called to give evidence to the Employment Tribunal? And given that he had apologised for his remark, the claimant felt that was a significant element to the claim. And if he had nothing to apologise, why did he do so? In essence, the employer's response to the appeal stage was that the claimant's own case confirmed that Mr. Cotter's comments resulted from the earlier comments made by him to Mr. Cotter about the journalist's report, and when Mr. Cotter was challenged by the claimant, Mr. Cotter immediately backtracked and apologised. It was accepted that the comment was unwanted, and that the conduct had the effect of humiliating him, and the EAT accepted this. The only issue was whether the Employment Tribunal had gone wrong in its analysis as to whether the conduct complained of was related to a religious belief or was it related to race. the EAT considered whether the absence of Mr. Cotter, who didn't give evidence, was necessarily fatal to the employer's case. The EAT accepted that the mental processes of the alleged harasser will be relevant to the question of whether the conduct complained of was related to a protected characteristic. However, it was not necessary that the alleged perpetrator gave evidence on this point. The tribunal could determine the complaint on the material before it, including evidence of the context in which the conduct complained of took place. The EAT then accepted the tribunal had looked at the discrimination test correctly and had then referred back to its findings on the direct discrimination claim and had applied the right test and come to a permissible conclusion that there was no harassment because the behaviour was not related to the relevant protected characteristic. So what does this case mean? Well, firstly, the case confirms that it's always necessary to look at the context in which offending comments or behaviour take place. Here, as the EAT indicated, if the case has simply been that Mr. Cotter had made an unsolicited comment without any prior history behind it about the claimant sporting ISIS, and that would seem to be a pretty clear-cut example of discrimination. However, the existence of the earlier conversation did cast a different light on this. Secondly, I think the employer was pretty lucky that it got away without calling Mr. Cotter to give evidence. Often it's a finely balanced decision whether it's better to call the maker of an unfortunate comment or to have those who dealt with the disciplinary issue give evidence. But here, there was enough surrounding evidence, and a lot of the facts were, in reality, not being challenged. However, the EAT does record at the end of its decision that there had been no ground of appeal on the failure to apply the burden of proof provisions in the Equality Act, and I wonder if there is a hint that, had the appeal been in a different way, possibly the absence of that witness might have been more important. I think overall the case, despite what it says, is probably leaning towards making it pretty risky not to have called the evidence of the relevant maker of the comment or the decider of the or the instigator of the allegedly offensive behaviour. In short, the Employment Tribunal had correctly taken into account the context in which an allegedly offensive comment was made in deciding it did not amount to direct discrimination or unlawful harassment. So, Berkali and Greater Manchester Buses (South) Limited, and why it's always important to look at the context in the case for any potentially offending material. So, third and final case, Afsal and East London Pizza Limited, better known as Domino's. So this is the case of a pizza delivery driver driving for Domino's Pizza who was dismissed because he failed to produce evidence of an in-time application extending his right to work in the UK. Central issue is whether, having been dismissed, whether he should have been allowed an opportunity to appeal. Did that make his dismissal unfair? So, background facts, he's a pizza delivery driver from 2009 to 2016, acting assistant manager, managing training, seen as a future branch manager. He had a good relationship with his manager. He's Pakistani by origin and had a time-limited leave to work in the UK, expiring 12th of August 2016. That date's going to be relevant. After that time, because he would have been a resident in the UK for 5 years, he would have a right to apply for a document showing that he had the right to permanent residence, and that would continue his right to work. He was not allowed to apply for this until 15th July 2016, so he had effectively got just under a month in which to complete the application. Provided he put the application in by 12th August 2016, he was entitled to carry on working while his application was considered. Clearly, the key legislation in this area is the Immigration, Asylum and Nationality Act 2016. It's an offence if an employer employs another, knowing that the employee is disqualified from employment because of that person's immigration status, and obviously it's a criminal offence. Unsurprisingly, the respondent, Domino's Pizza, had an experienced team dealing with immigration issues, and the relevant member of the HR team, Mr. Cunningham, wrote to the claimant on 3rd June 2016 and again on 15th July 2016, reminding him that he needed to make an in-time application and provide the company with evidence that he had done so. He was told he had to do this by 11th of August. The claimant did not respond. Mr. Cunningham continued trying to manage the situation. Now, it was subsequently accepted that the claimant did ultimately make an in-time application. Therefore, he was, at all material times, entitled to work in the UK. But he did not provide this information or the evidence of his application stay until late on 12th August 2016 itself, the very last day. Although the claimant apparently did try and send the information to Mr. Cunningham couldn't open the attachments, and therefore on the expiry of 12th August, i.e. later the same day, the company, which at that point had no evidence that the claimant was entitled to work in the UK, and it was concerned to avoid any risk to the company, and so the company took the view that the claimant had to be dismissed with immediate effect, and that is what happened. No procedure was followed prior to the dismissal of the claimant, and there was no right of appeal. The employment judge accepted that the reason for dismissal was some other substantial reason, i.e. the respondent genuinely believed that the employment was prohibited by statute. It was not, in fact, the case that the employment was actually prohibited by statute, and so the tribunal accepted as well that the employer's belief was reasonable, and that it was reasonable for them to act decisively on 12th August because of the worries about criminal and civil penalties. All fine so far. However, there was no appeal offered to the claimant after he was dismissed, and the employment tribunal judge said it was generally good practice to include a right of appeal. He knocked back a suggestion by the employer's lawyer that it might be inconsistent with immigration law for such a right to be included, because that might imply some form of employment relationship was continuing, which would of course be a criminal offence. The judge simply didn't accept that point, and there was no legal argument in favour of that proposition, he said, and in the past appeals have been permitted without any particular difficulty for the employer. However, tribunal judge went on to say that in his opinion there was nothing to appeal against. The test which the employer had to apply was whether, before the date of expiry of permission, it had reasonable grounds to believe the claimant had made a valid application for an extension. Having come to that view, the appeal was never going to come to a different decision, looking as it would be, as at 12th August. There was no basis for the employer, the employment tribunal said, to back-calculate or backfill a belief it did not have on 12th August. On that basis, although the claimant had not been offered an appeal, the dismissal was still fair. Well, the EAT said, in modern employment relations practice, the provision of appeal is virtually universal. And they pointed to disciplinary cases and what is said in relation to the ACAS Code of Practice, and it should be a starting point in applying the basic test for unfair dismissal generally. Here, although the employment judge had found that there was nothing to appeal against, the EAT disagreed. The dismissal was based on the employer's genuine belief that the claimant's employment was prohibited by statute, some other substantial reason. If an appeal had been offered and the claimant had produced evidence which satisfied the company that he was entitled to work, the employer could have rescinded its dismissal without fear of prosecution or penalty. Obviously, there was no question of prosecution if the relevant employee was, in fact, entitled to work. Obviously. The EAT accepted that, had an appeal been offered, this information could have come forward in a number of ways. Claimant could have provided the documents himself. The company might have accepted the word of the claimant's solicitor confirming the situation, or made its own inquiry of the employment checking service. Therefore, reinstatement was not impossible, nor an appeal futile, and one should have been offered. The matter was sent back to the Employment Tribunal to consider whether on the facts of this case that made the dismissal unfair. And I think there's a fairly broad hint from the EAT that that is what they would decide, but also that there may well be some sort of contrib fault because the situation arose partly through the fault of the employee. I think the case is useful because it corrects a misapprehension which we've certainly heard before. Employees who are being dismissed for a failure to comply with the Immigration and Nationality Act about work permit requirements are entitled to a fair process. It may well be that if the dismissal is inevitable, the tribunal would say that a decision to dismiss, even if reached unfairly, had no loss to the employee. But crucially, if there is an unfair process and it turns out that the employer's understanding is wrong, then the employer is going to be liable potentially for significant damages. So that's the case of Afzal and East London Pizza Limited and why an appeal process should have been offered here. So I think all that remains for me to say is thank you very much for listening. A slightly longer podcast this week, but I hope it was been useful. We'll be back in a couple of weeks' time. We've hoped to have a guest podcast in the meantime, but I'll talk about that when I know for certain it's going to happen. So until probably 2 weeks' time, maybe 1 week's time, but until 2 weeks' time, stay safe, take care, and look forward to speaking again on podcast number 142 or the guest episode. Cheers.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.